Hello everyone, it's a pleasure and a privilege to participate in this event. The title of my work is Constitutional and Legal Framework of the Deprivation of Liberty, Fundamental Rights, Goals of Penalties and Procedural Guarantees. In the old days, punishing meant public revenge, namely through death in a public square and provocation of physical damage, in a logic of an eye for an eye and a tooth for a tooth. However, that has changed with humanist movements, which have forced to treat the convicted with dignity. The deprivation of liberty is the most serious sanction, which, however, must respect human dignity and the right to personal integrity. Death penalty is constitutionally prohibited under Portuguese law, as well as penalties with a perpetual character or of unlimited or indefinite duration. The method we used for this study was an essentially expository and descriptive method with qualitative content composed of legislative and doctrinal analysis. With regard of the purposes of penalties, we can say that, for absolute theories, punishment is conceived as an absolute metaphysical and ethical requirement, secondary to the pure demand for justice. For the retribution theories, the demand for punishment, in accordance with justice, translates into the conception of the penalty as a punishment, so that the evil of crime is answered with the evil of penalty, as a way to repair the evil committed. For relative theories, the legitimacy of the penalty depends on its need and effectiveness to prevent the practice of crimes, so the penalty is not justified by itself, but it has a relative and circumstantial purpose, a utility, which is translated in the circumstance of functioning as an obstacle to the practice of new crimes. The theory of special prevention aims to dissuade the convict from the practice of new crimes. For the theory of general prevention, the penalty serves as an example in order to intimidate potential criminals. Articles 20 and 32 of the Constitution of the Portuguese Republic, respectively, provide defense guarantees such as access to the law and effective judicial protection, and, specifically, guarantees of criminal prosecution. In addition, the Penal Code regulates several guarantees of convicted. Nowadays, the social reintegration of the convict is one of the essential objectives of criminal law, so the state must provide the convict with all the necessary conditions for his reintegration into society. As conclusions, we can say that in a democracy ruled by law, the intervention of criminal law is only justified in obedience to the constitutional principles of necessity and subsidiarity. Criminal sanctions cannot be dissociated from another principle as an insurmountable limit of the penalty, the principle of guilt. So, in no case can there be a penalty without guilt, or the measure of the penalty exceeds the measure of guilt. Penalties, even the deprivation of liberty, will in no way put into question the principle of dignity of the human person and the guarantees of defense of the condemned. Thank you.